Yes, before starting anything, let me ask you people if you are having any question in your mind with regard to any topic out of this CRPC. Everything is clear? Avneet, you are having one. Take this mic. Take this mic. It will be helpful. Yes.
In section 216, it has written
216 of a,
regarding the charge, CRTC.
okay, alteration of charge.
That charge can be altered or added. Can it be subtracted also?
Subtracted. It can be. It can be deleted, we can say. If some charge has been framed under one section which is not applicable, it can be deleted. There is every power with the judicial magistrate to alter the charge. Alter mean to delete, to add, whatever. Alter word itself means that it can be added, it can be deleted. But in case the magistrate did not delete that, let us see that eventuality. That what will happen that ultimately when the judge will decide the case, he will acquit the accused under that section, that there is no charge, there is no evidence against him under that section under which a charge was framed. Yes, are you clear? Everything can be done because it is handmade. Charge is handmade. It can be changed at any time. What is in fact charge? Charge is we are disclosing to the accused, look here, these are the charges against you. We are going to try you under these sections. We are informing him. And he will read his evidence. The prosecution, public prosecutor will also read his evidence. Then we will decide at the end that, because at the end also, whatever may be in the charge, now the judge is concerned with the evidence. That evidence proves what we have discussed in section 220, 221 also, 222 also. That even if we have not framed the charge, the court can convict the accused under various other sections. We have discussed there that if the accused was charged with section 326 of IPC, and the court can convict the accused under section 335 of IPC, because that is, it is not similar, but we can say minor offense, minor of the major offense. Are you clear? Yes, anybody who wants to ask any more question? Everything is clear. Yes, let us see, Mankirat, you take the charge of this mic. Yes, students, on that day, what we are doing in these days, we are discussing what is evidence, how the evidence is recorded. This is one of the most important work of the court, because it is the evidence on the basis of which judicial magistrate is to give punishment to the accused. It is the evidence on the basis of which appellate court, session judge, is to acquit the accused, is to convict the accused. It is that evidence on the basis of which High Court or Supreme Court will proceed further. That what is the position, whether really there is evidence to prove some offense or not. Therefore, evidence is very, very material topic. Therefore, you have to note down each and everything, whatever I dictate with regard to evidence. Because we have discussed earlier that how in warrant cases, evidence is recorded by the JMS. We have used the word verbatim, that the judge will write each and everything what is being spoken by the witness. He cannot speak and escape any word out of that. He will have to write whatever he has disclosed, each and everything. full disclosure should be contained in that statement. Then we have discussed that how the session judge is recording the evidence in all the cases. He should also record in the same way. He should write each and everything in that too in narrative form. We have discussed that it will be in the first form. We will write that. But sometimes question may arise that the judge wants a specific answer from the witness. Then he can write the question. He can write the question in the statement itself, that what was being done by you on specific date at specific time. Now we are seeking specific answer. Then whatever he gives answer, we will write their answer. Now this is the statement. Let us proceed further with some more provisions with regard to a recording of statements. On the day we have completed section 276. We have completed. All right. 227.
Section 277 CRPC, language of record of evidence.
Yes. Now we are concerned with language. That which should be the language. Earlier I disclosed to you people that all statements are recorded in Punjabi in Punjab, Hindi in Haryana, because that is the official language of the state. It is the state government who has declared we are to write the statements in Punjabi. Now let us see, if somebody is coming from Tamil Nadu, if somebody is coming from West Bengal, he is not knowing Punjabi, he is knowing Bengali. Now the person who is coming from Tamil Nadu, he is knowing Tamil only. How we can write in Punjabi? We will discuss that situation also in this section. Let us see. Yes.
In every case where evidence is taken down under section 275 or section 276.
Yes, students. Now remember that 275, it is dealing with the statement recorded by judicial magistrate in warrant of peace. Then other section is relating to session judge who is recording evidence under section 276. All right.
In every case where evidence is taken down under section 275 or 276A, if the witness gives evidence in the language of the court, it shall be taken down in that language.
Let me simultaneously dictate you so that you may not be confused. Instead of reading all, write in your copy section 277, clause A. If a witness is giving statement in Punjabi, comma, then in Punjab, every subordinate court is supposed to write his statement in Punjabi, because Punjabi is our official language, duly declared by the state government. Yes, B point.
B. If he gives evidence in any other language, it may, if practicable, be taken down in that language, and if it is not practicable to do so, a true translation of the evidence in the language of the court shall be prepared as the examination of the witness proceeds, signed by the magistrate or presiding judge, and shall form part of the record.
Yes, let me dictate you. In case somebody is coming from Madras or Tamil Nadu or West Bengal and wants to give evidence in his own language, that is Kannada, Tamil or Bengali, then the true translation in Punjabi must also be brought on a record of the court. First of all, in such a case, the court can seek the help of some expert in that specific language for translating the same into Punjabi, so that in future there may not be any ambiguity. Oh, yes, it's very important thing here I am going to dictate you next. Sometime it may happen that a dispute arises with regard to specific line or word, that somebody says that exact substitute of Punjabi has not been written in the statement, which creates ambiguity. First of all, such a question had arisen before Honorable High Court of Maharashtra, Bombay High Court, in a case titled as State of Maharashtra versus spellings are on the board, Bhanru. It was division bench in 1996. Criminal Law General, page 673. And Honorable High Court has held that if there is a dispute over interpretation or over meaning of specific word, between the statement recorded in Punjabi and the statement given in other language, that is Bengali, Tamil or Kannada or Marathi, then the statement of the witness given in other language will be prevailing over the statement recorded by way of translation. Yes, students, you might have found that many times the Punjabi words, there is no specific word in English. Then we have to guess, we have to take which is near meaning. Then we put that. Now, if such a dispute is there, we have to look into the original language in which the witness has been examined. Yes, read this B point again.
If he gives evidence in any other language, it may, if practicable, be taken down in that language, and if it is not practicable to do so, a true translation of the evidence in the language of the court shall be prepared as the examination of the witness proceeds, signed by the magistrate or presiding judge, and shall form part of the record.
Yes, students, here I will dictate you much. Next para. Suppose a witness in Punjab wants to give evidence in Hindi, and Hindi is known to all of us, comma, his evidence can be recorded in Hindi also. Because it is practicable to do so throughout India. All right, come to C point.
C, where under clause B, evidence is taken down in a language other than the language of the court, a true translation thereof in the language of the court shall be prepared as soon as practicable, signed by the magistrate or presiding judge, and shall form part of the record,
Yes, next paragraph.
provided that
No. Let me dictate you in next para in your copy. Whenever statement is recorded by way of translation also, then both original statement in other language and translation in Punjabi shall become part of the file. Yes, now come to provision.
provided that when under clause B, evidence is taken down in English and a translation thereof in the language of the court is not required by any of the parties, the court may dispense with such translation.
Yes, let me dictate your next para. In case the evidence has been recorded in English and nobody has required its translation, comma, then there is no need to translate the English writing into Punjabi writing. Because judgments are written in English in Punjab and Haryana. Next paragraph. Section 277 makes it crystal clear that evidence on the basis of which the court is to convict the accused or the court is to acquit the accused must be in Punjabi, and if not in Punjabi, then in English, comma, otherwise. Translation of other languages must be on the file. First off, this has been done so that whichever judge is to decide the case, he may not face any difficulty in interpreting the evidence. I hope everybody is clear. If you are having some question, you can raise the question. Yes, Ahmed, have you understood? Everything is clear? Satyam? Yes, very good. Understand while sitting in the class. Now let us see next another very important section. Yes.
Section 278 CRPC procedure in regard to such evidence when completed. Subsection 1. As the evidence of each witness taken under section 275 or section 276 is completed, it shall be read over to him in the presence of the accused, if in attendance, or of his pleader, if he appears by pleader, and shall, if necessary, be corrected.
Yes. Very, very important. Let me dictate you here. One question. Whether a statement are recorded by the court can be corrected. Oh, yes, students. Firstly, I will tell you that how statement is written in the court. You should prepare one statement here on the board. Let me dictate you here. Whenever the court record the evidence of a witness on a document, then firstly it starts from on essay, rightful form, on Solomon affirmation. जो मैं कह रहा हूँ फिर मैं सच कह रहा. This is the Solomon affirmation. Then here PW1, if he is prosecution witness, if he is the witness of accused, defense witness, DW1, 2, 3, like that. Then whatever he states, write this thing also, whatever he states, we write in this statement. I think is it visible to all of you? I will bring out in front of you. This is very important. Write in your copy like that. This is the statement. Prepare a page like that. Write here like that. This is the statement. This is very important, students. Now here, why I have drawn this? We will write RO and AC. Now right here, what is the meaning of RO and AC? RO and AC stands for read over and admitted correct. It means this statement has been read over to the witness and to the accused also, and to the pleader of the accused also. Then on this side, judicial magistrate will put his signatures, JMIs. Now here, signatures of the witness will be taken under RO and EC. Have you seen ever the statement in the court? Yes, Hemant, have you visited that? This is how we record the statement. We do write there are O and AC because we have explained that after writing. Now write next. Once the statement has been written on oath, comma, it is general law that the witness cannot retract, cannot become hostile by saying that he want to give a different version. First of all, once the statement is signed by the witness, comma, that is final. Yes, and this concept is also very important. Next paragraph. But sometime, next paragraph. But sometime a witness may say that, sir, I got recorded this word in 7th line of the statement, but the reader has written some other word. First of all, the court cannot make any amendment in the statement, comma, but the JMIC will write a memorandum at the end that the witness has expressed his desire to make correction in the statement on the ground that some specific word should be inserted, because he spoken that word. For example, witness spoke, put it in commas, Mohanlal visited his house. And reader has written Sohanlal visited his house. Oh, yes. The judicial magistrate will write in his memorandum that the correction is liable to be made because the error occurred due to accident, comma, then the judge can express his remarks and can record there that it should be read as. I hope all of you have understood that what is the procedure. If some word has been spoken wrongly or some word has been written wrongly, then what is the procedure? Procedure is specific. We cannot directly make any change in that unless we record, because once the statement has been given on oath, now that is authentic statement, because whatever the witness has said, we have recorded that. Now we cannot make any change. Witness cannot also do that, except if the error took place accidentally or it is a arithmetical mistake. For example, a person, he has spoken 70, but the reader has written 70. That's good ground to replace this. If he says that I have spoken 70, but he has written 70. It happens many times. All right, now let us see once more, read this 278 so that you may be very clear about that.
Section 278, procedure in regard to such evidence when completed. Subsection 1. As the evidence of each witness taken under section 275 or 276 is completed, it shall be read over to him in the presence of the accused if in attendance, or of his pleader if he appears by pleader, and shall, if necessary, be corrected. Subsection 2. If the witness denies the correctness of any part of the evidence when the same is read over to him.
Yes, this is the read over. Read over or read over. We have read over the same to him. Yes.
The magistrate or presiding judge may, instead of correcting the evidence.
Yes, please highlight these three words. Instead of correcting evidence, he will not correct the evidence directly. He cannot substitute any other word. Yes.
Make a memorandum thereon.
Highlight that memorandum. Yes.
Thereon of the objection made to it by the witness, and shall add such remarks.
Yes, please highlight these three words. Add such remarks, because he is to give his opinion whether really this change is required or not. Only then he can make the change. Yes. Add.
And shall add such remarks as he thinks necessary.
All right.
Subsection 3. If the record of the evidence is in a language different from that in which it has been given, and the witness does not understand that language, the record shall be interpreted to him in the language in which it was given, or in a language which he understands.
All right, let me dictate you here. In case somebody has given evidence in a different language from Punjabi, then he must be informed about each and every interpretation of words. Yes, students, now here very, very important point. Now, write in next para. Whenever evidence is recorded, the opposite counsel put questions in cross-examination and he has to record various suggestions also. Like, it is wrong to suggest, this is very important, students. It is wrong to suggest that I have committed a wrongful act. Next, it is wrong to suggest that I have committed theft in the last year. It is wrong to suggest that I have participated Let me ask you, have you understood these three words, three lines? What is the meaning of that? Yes, Raman, can you explain? What is the meaning of these three lines? Yes, Mankir. It is wrong. Yes, students, many times the witnesses raises dispute. Sir, here it has been written that मैं चोरी कीती है, मैं murder ਦੇ ਵਿੱਚ participation ਕੀਤੀ. Oh, it is wrong to suggest they are not reading that. They are putting that on one side. They are simply reading, sir, this is wrong. It has been wrongly written in my statement. And many times they refuse to put signatures. Many times, because many people who are coming from the villages, they are illiterate. When in Punjabi, the advocate is writing that ये गलत है कि मैं कल चोरी की थी. Witness, he will say, this is absolutely wrong. मैं चोरी की थी. ये गलत वाली गाल नहीं उन्हें देखनी. He is not going to that. So this is suggestion. Whenever somebody says that I have not committed any wrong, I have not participated in murder, now the opposite counsel must give suggestion that it is wrong to suggest that you have not participated or you have participated, whatever maybe. Why? Because the opposite counsel is to prove the opposite thing. If the person is saying that he has not committed theft, the opposite party will bring before that, look here, sir, this CCTV footage that he was stealing something from the house. Now, in that form, why? Let me now dictate you here. Now, whenever these suggestions are given to the witness, they are given to take action against the witness for punishing them for giving false evidence. That is why the opposite party want to make it crystal clear that the witness is saying categorically that a specific thing is wrong. Question. If the case is proved that such specific thing is right one, comma, then the witness can be prosecuted for giving false evidence. All right, let us see now next section, next provision.
Section 279 CRPC, interpretation of evidence to accuse or his pleader. Subsection 1. Whenever any evidence is given in a language not understood by the accused and he is present in court in person, it shall be interpreted to him in open court in a language understood by him.
Yes, students, let me dictate you here. Copy. Whenever the evidence is recorded in English and the accused is illiterate, or if the evidence is recorded in Hindi and the witness is also not knowing Hindi, comma, then it is the duty of the judicial magistrate to explain the meaning of each and every word to the accused. And if there is a pleader of the accused or advocate of the accused, then he is also informed the meaning of some word if he is not well familiar. Yes.
Subsection 2. If he appears by pleader and the evidence is given in a language other than the language of the court and not understood by the pleader, it shall be interpreted to such pleader in that language.
Yes, that language. Yes, students, simply the new law has substituted advocate in place of a pleader. And there is no other change. Yes.
Subsection 3. When documents are put for the purpose of formal proof, it shall be in the discretion of the court to interpret as much thereof as appears necessary.
Yes, let me dictate you here also. Whenever a document is proved and the accused wants to understand that document, the court may briefly interpret the whole contents. All right.
Section 280 CRPC remarks respecting demeanor of witness. When a presiding judge or magistrate has recorded the evidence of a witness, he shall also record such remarks, if any, as he thinks material respecting the demeanor of such witness whilst under examination.
All right. I will ask you people, what is the meaning of demeanor? Do you know the meaning of Arshita? Have you heard this word earlier? Yes, Satya? Do you know the meaning of that? Proper? Yes, Hemant? Have you heard this word earlier? Yes? Yes? All right, all right. Yes, Mangir? Have you heard that? Yes, Tony. Huh? Yes, we can say manner of expressing the thing, facial expression. Now write in your copies. What is the meaning of? Because very important word, not minor. What is the meaning of demeanor in section 280? Demeanor mean how a witness is behaving in the court and what is the conduct of the witness in the court and what is facial expression of the witness and what is attitude of the witness during questioning. Yes, students, this is very, very important here. Let me explain that. In India, we are well familiar that how many advocates they tutor their witnesses and they ask the witnesses to cram this thing and speak in the court. And that is a false. And you have always heard that once it is the thing is based on falsehood, you have to cram that. If you want to express your natural version, there is no need to cram. The person who has been tutored, he may fall at any time because the thing which is based on falsehood cannot succeed ever. Now, what do they do in the court? Now, they tutor the person that whenever somebody asks you question, give the answer only yes or no. Now, advocate, they train them. Oh, they train that when he will raise one finger, you say yes. When he raise two fingers, you say no. And in such a way, when evidence is being recorded in the court, whenever any question is asked from him, he is watching his fingers, that whether it is one or whether it is two. Now, this is the demeanor of the witness. And we have to control that. Suppose in a court, the judge has observed the conduct of the witness, demeanor of the witness, that whenever any question is asked, he is watching somewhere to seek some answer. Then he sent the advocate out who is giving indication one or two. Now the witness, he becomes helpless. You can well imagine that what will be his position. Now questions are asked, he is confused. Then he gave the truth to the judge. Sir, whatever has been crammed by the advocate, whatever has been tutored by the advocate, I have spoken here, I don't know anything else. Now you can well imagine that what will be there. Now write in next para. The court is supposed to watch the demeanors of the witness because it will have to record in the statement itself that it has observed specific witness who is seeking answer to every question from someone through indications. And such a statement will never be treated to be credible or reliable. First, the duty of the judge is to ensure that no witness is telling a lie in the court. First, otherwise also the JMIC and every criminal court is competent to initiate the proceedings against the witness who is telling a lie. For prosecuting him under section 193 of IPC. All right. Now let us see next.
Section 281. Subsection 1. Whenever the accused is examined.
Yes, students, here you may not be confused because this first para has been deleted. You may write here and there both. First para of Cr.PC has been deleted in BNSS. It is not there. But I will dictate you, we will read that so that you may know the history of that. Yes.
Subsection 1. Whenever the accused is examined by a metropolitan magistrate, the magistrate shall make a memorandum of the substance of the examination of the accused in the language of the court, and such memorandum shall be signed by the magistrate and shall form part of the record.
Yes, student, let me dictate you here, write in your copies. Section 281, subsection 1 of Cr.PC, underline that. This subsection has been deleted by the Parliament while framing the wording of section 316 of BNSS, because the word metropolitan magistrate has been deleted in entire BNSS. First, under section 281, subsection 1, earlier metropolitan magistrates were competent to write the statement of accused in a brief manner, not recorded verbatim, that is word by word. But now, no such provision is there, and every court is supposed to record the spoken words of accused verbatim, that is word by word. First of all, statement of accused is not recorded on oath, comma, but it is recorded in the form of question answer, comma. Therefore, whatever answer will be given by the accused, comma, it will be recorded by the judge. First, earlier metropolitan magistrate was to write only substance of contents spoken by the accused. All right. Next. Yes, students, subsection 2 under 281 has been converted into subsection 1 in BNSS. Yes.
Subsection 2. Whenever the accused is examined by any magistrate other than a metropolitan magistrate or by a court of session, the whole of such examination, including every question put to him and every answer given by him, shall be recorded in full by the presiding judge or magistrate himself, or where he is unable to do so owing to a physical or other incapacity, under his direction and superintendence by an officer of the court appointed by him in this behalf.
Yes, students, I will declare you one question which has appeared many times in main examination. Write in your copies. What is the procedure of a recording statement of accused? Yes. Section 281 of Cr.PC and section 316 of BNSS provides a specific procedure for recording the statement of accused. First of all, on the other hand, section 313 explains in which circumstances the statement of accused will be recorded. Next para. Section 281 of Cr.PC and 316 of BNSS explain that a statement will be recorded by the judicial magistrate in question answer form without oath. First up, the purpose of this recording statement is to disclose to the accused the incriminating material against him. Existing in the evidence, so that the accused may be able to give appropriate explanation to that incriminating material. First off, it is the wish of the accused to give reply or not to give reply, or to give false reply. But if he gives a false reply with regard to some facts which is a crime, then his statement can be utilized for prosecuting him. And it may be treated to be his confession. So, for example, in a case of theft in house number 10, one question was asked from him as to whether he has committed theft in house number 10. Comma, he said that he never committed theft in house number 10. No, he has added here unnecessarily. Write this thing. He has added unnecessarily, put it commas. I have not been prosecuted. I have not been prosecuted for the theft in house number 20, which I committed last year. First up. Now there is an FIR registered in the police already about theft in house number 20. Comma. Now statement of accused can be utilized by the police in conducting investigation. I hope all of you have understood this statement of accused. Let me take you people first of all to section 313, because only then you will be able to have grip over that. What is statement of accused? 313 of CRPC.
Section 313, power to examine the accused.
Yes, you can simultaneously see here also, which is a section in BNSS, so that you may see whether there is a change or not. 351. Yes.
Subsection 1. In every inquiry or trial, for the purpose of enabling the accused personally to explain any circumstances appearing in the evidence against him, the court may at any stage, without previously warning the accused, put such questions to him as the court considers necessary. And B.
All right. Let me dictate you here also. Section 313, subsection 1, clause A. The JMIC or any other criminal court is having full power to record the statement of accused at any time whenever one witness has been examined or two witnesses have been examined, comma. This is discretionary power. And the court may not record, but when entire evidence of the prosecution is concluded, comma, then it is mandatory on the part of the judicial magistrate or any criminal court to record the statement of accused. Please highlight the word may. I hope you might have earlier done that, but you have forgotten that. That's why I have dictated. All right. Yes.
Shall, after the witnesses,
Yes. Now, shall also underline that because it is mandatory. Yes, shall.
shall, after the witnesses for the prosecution have been examined and before he is called on for his defense, question him generally on the case.
Yes. Question him generally mean to record the statement in writing in a question answer form. Yes.
So, provided that in someone's case where the court has dispensed with the personal attendance of the accused, it may also dispense with his examination under clause B.
Yes, we have discussed in section 253 Abi. Yes.
Subsection 2. No oath shall be administered to the accused when he is examined under subsection 1.
Yes. We have discussed earlier also this section, but since we are discussing that how it is to be recorded, it is quite necessary to refresh your memory also. Yes.
Subsection 3. The accused shall not render himself liable to punishment by refusing to answer.
Yes, he may refuse. He may say that I don't want to say anything. Now we cannot take action against him. Yes.
By refusing to answer such questions or by giving false answers to them.
Yes, he can give false evidence. But if that false evidence is somewhere involved, then certainly we will take action against him. Yes.
Subsection 4. The answers given by the accused may be taken into consideration in such inquiry or trial and put in evidence for or against him in any other inquiry into or trial for any other offense which such answers may tend to show he has committed.
Yes, may tend to show. Example I have given to you is
Subsection 5. The court may take help of prosecutor and defense counsel in preparing relevant questions which are to be put to the accused, and the court may permit filing of written statement by the accused as sufficient compliance of this section.
yes. Let me dictate you here. The JMIC or any criminal court may allow the accused to give his written statement or rebutting all the allegations against him. First of such a statement given by the accused will serve the purpose contained in section 313 of CRPC. All right, students, we will take break here so that you may take test.